Let's move on to compulsory licensing in India. This is slide number 8 of your presentation. Its compulsory licensing regime in India is broadly encapsulated in Chapter 16 of the Patents Act from sections 82 to 94. They can broadly be categorized as abuse of patents and number 2, public interest requirements. Let us first look at number 1, abuse of patents. Section 84 of the Patents Act states that any party interest may apply for the grant of a compulsory license on the following 3 grounds. First, that the reasonable requirements of the public with respect to the patented invention have not been satisfied, or second, that the patented invention is not available to the public at a reasonably affordable price, or 3, that the patented invention is not worked in the territory of India. Thus, the 3 grounds are reasonable requirements of the public, or reasonably affordable price, or not worked in the territory of India. Any application for the grant of a compulsory license under Section 84 must contain at least one of the above grounds. It is also relevant to note, however, that these concepts can be overlapping, and that is, one may lead to another. Prior to the grant of a compulsory license, though, Section 84(6)(4) of the Patents Act requires that the applicant has made efforts to obtain a voluntary license from the patentee on reasonable terms and conditions, and that such efforts have not been successful within a reasonable period as the controller may deem fit. This is later clarified that the reasonable period does not ordinarily need to exceed a period of 6 months. Let's look at the first case, BDR versus Bristol Myers Squibb, BMS for short. In March 2013, BDR filed a compulsory license application under Section 84 of the Act for dasatinib, that is an anti-cancer drug whose patent was held by BMS. This was only the second compulsory license application to be considered under the section till then. BDR first sent a letter seeking a voluntary license on 2nd February 2012, and BMS responded to this on 13th March 2012. In their response, BMS set forth a list of questions regarding whether BDR would be able to work the patent. However, BDR did not send a reply to this and directly filed a compulsory license application the next year. Now, as per Rule 97 of the patent rules, the controller is to notify the applicant if he or she is satisfied that the prima facie case is not made out. The controller accordingly notified BDR that it had failed to make out a prima facie case for the grant of a compulsory license on 2 grounds. First, the failure to make reasonable efforts to obtain the license from the patentee, and secondly, the failure to obtain regulatory clearance for the drug. Hence, it was denied. Now we move on to reasonable requirements of the public. The test of reasonable requirement of the public is found in 39 of 41 prominent developing countries. It's also mentioned in the Paris Convention, which says the lack or insufficient working of the patented invention is a ground for the grant of a compulsory license. Looking at the Indian legislation, certain acts are deemed as failing the test of whether reasonable requirements of the public have been met. These include, firstly, if by reason of refusal to grant a license on reasonable terms, the continuance or development of an existing trade or industry, or the establishment of a new trade and industry is prejudiced, a compulsory license shall be granted. Secondly, if the demand for a patented article has not been met to an adequate extent and on reasonable terms, a compulsory license may be granted. Thirdly, if a market for export of the patented article manufactured in India is not being supplied or developed, a compulsory license may be granted. The ambit of this provision remains unclear, however, as does its TRIPS compliancy. This is because Article 31F of the TRIPS agreement, which requires that a compulsory license be granted predominantly for the supply in the domestic market. However, Section 90, Subsection 1, Subsection 7 seems to qualify this provision by stating that the controller shall endeavor to secure that the license is granted with the predominant purpose of supply in the Indian market. However, the same subclause also refers to Section 84(7)(a)(3) for terms on which an export license may be given if need be. It must be noted that as per the Doha Declaration and its implementation decision, exports of pharmaceutical products to countries with no manufacturing capabilities is permissible. Then the next test looks at if by reasons of conditions imposed by the patentee upon the grant of the licenses or purchase or hire or use of the patent, the manufacture, use or sale of materials not protected by the patent, or the establishment, development of any trade or industry in India is prejudiced. If this happens, then a compulsory license may be granted. Moving on, if there are coercive and grossly unfair licensing terms, such as exclusive grant-back or prevention of challenges of validity or coercive packaging licensing, etc., these are also conditions under which a compulsory license may be granted. And then, if the patented invention is not worked on a commercial scale to an adequate extent in India, Section 83 describes the general principles for interpretation and also talks about the working of the patented invention on a commercial scale. If the working of a patented invention on a commercial scale in the territory of India is being prevented or hindered by the importation from abroad of the patented article, a compulsory license may be granted. Now we'll move on to the next requirement, that is reasonably affordable price. Section 84(1)(b) requires a determination as to whether the price at which the patented product is made available to the public is reasonably affordable or not. This can be decided on a case-to-case basis. However, the IPAB held in Bayer v. Nutco that a determination of whether a price is reasonably affordable to the general public does not hinge upon the cost of the product, but is rather determined from the consumer's perspective of whether the product is or is not affordable. We'll discuss this case a little later in more detail. But we'll now move on to the third requirement, that is, working of the patent within the territory of India. Section 84(1)(c) provides that an application for a compulsory license can be made when the patented invention is not worked in the territory of India. In Bayer v. Nutco, the IPAB linked this working requirement to the earlier ground listed in reasonable requirements of the public. However, as just mentioned, the decision by the IPAB then went on to hold that import could amount to working and is to be decided on a case-to-case basis. However, if we look at Section 83, it indicates that the controller at the Patent Office may have held an interpretation that is more consistent with the legislation. This is because Section 83(b) and (c) state that patents are not granted merely to enable patentees to enjoy monopolies for the importation of patented articles, and 83(c), which states that the protection and enforcement of patent rights contributes to the promotion of technological innovation and to the transfer and dissemination of technology. As Article 27 of the TRIPS agreement mandates no discrimination between locally produced and imported patented products, there have been questions about whether a local working provision would be a legitimate one at all. This question was brought up in a WTO challenge by US to Brazil's patent regime, which included a similar local working provision. However, the case was eventually dropped, so there was no ruling on this. Arguably though, such a provision would be a valid one. In the Canada Patent Protection of Pharmaceutical Products case, the WTO panel held that discrimination refers to unjustified discrimination, thus allowing for justified differentiations, if any. As the Paris Convention, as incorporated into the TRIPS agreement, clearly draws a distinction between working and importing, there is an indication that non-working, and even if importing, could be treated as an abuse of patent. Further, a local working provision is more in sync with the promise of technology transfer that TRIPS that the TRIPS is premised upon. It has to be noted that a local working requirement does not necessitate the setting up of a manufacturing unit by foreign companies, as licensing the manufacture to local companies could also be used to fulfill this requirement.